footage, listen carefully. First was Gary Creep, and then you'll hear Orly Tates. And notice they interrupt Gary Creep constantly, and whether he has even standing. That means the right to even come in court. Do you have the right to come in court even? We don't want to even look at your issues till you show us you have the right. Gary actually doesn't have the right. But Orly Tates did. We'll go to that, and we'll be back right before the end. Thanks for watching this. You're seeing something that is history-making. It's being questioned, and his right and qualification to even be president. And Orly brought that issue before he was sworn in. That's part of the reason she has standing.
If it pleases the court, my name is Gary Creep. I'm an attorney with the United States Justice Foundation. I'm here to represent Mr. Drake and Mr. Robinson and those clients alone. It is the purpose of our appeal, which is one of the two appeals combined for hearing today, to seek a remand back to the trial court so that we can separately pursue a resolution of this issue so that we can have the case ruled on the merits and not dealt with on the various technical issues that have been raised or on issues that relate to plaintiffs, not my own. As part of my presentation, I will only be dealing with the parts of the ruling by Judge Carter that deal with my clients, as there's a variety of issues raised by the other plaintiffs which I have no stake in.
Could you make clear right at the outset what relief you're seeking?
Yes, we're seeking a remand back to the trial court so that we can
ultimate relief.
Ultimate relief. We're seeking in our proposed second amended complaint that the court reach a determination as to whether Mr. Obama is eligible to serve as President of the United States. That is the ultimate relief we are seeking.
And what remedy flows from that you are seeking?
Well, we're seeking simply a declaration that that is so, if we're able to present the evidence to the court to prove that.
And then what would you expect, or what are you asking the federal district court to do assuming it were to issue that declaration? What would be the next thing that would happen?
Well, the next thing that would happen would be that if the federal court system, because this will go all the way to the U.S. Supreme Court no matter what.
Well, let's just talk about where we are. Yes.
Well, if the court were to remand it back and we went through the procedures and had a trial on the merits, and the court found that Mr. Obama was ineligible to serve in the office, it would be our expectation that the office would ultimately, not necessarily by the court, but the office would be vacant and Mr. Biden would take over as President of the United States pursuant to, I believe, the 20th Amendment.
Thank you.
Now, your clients are former candidates? Is that who they are?
Your Honor, Mr. Drake, Pastor Drake, was in 2008 the vice presidential candidate of the American Independent Party on the ballot in California. My other client is Markham Robinson, who was at the time the chairman of the American Independent Party in California. And pursuant to the Hollander decision, both such individuals, Mr. Robinson on behalf of his party and Mr. Drake as a candidate, have standing to challenge the
But the case was filed after the election was over.
Yes, ma'am, I'm aware of that. I was not involved.
Why do they have standing? Why are they any different than anybody else at this point?
Well, because, first of all, Your Honor, I can't speak to why it was filed after the election.
I'm not saying why. I'm just saying because it was filed after the election, they no longer have an interest in the election. The election's over. So what is it that distinguishes them from anybody else?
Well, Your Honor, first thing, this is a matter that
They're not asking the election to be rerun. They're not declaring that they want to run in the next election. So what's their role here?
Well, we're not asking that the election be rerun, Your Honor.
Right.
We're not asking that the government be shut down.
And you're not alleging that you're not saying that you want this relief because you're planning to run next time.
Well, it's premature, Your Honor, to even speculate whether Mr. Drake would run next time.
Okay. So you're not alleging that. So why are you different from anybody else?
Because this matter, well, first of all, because there is a ruling that they could challenge it from a federal court, number one. Number two.
I'm sorry? What case is that?
The Hollander case, Your Honor.
Wasn't that somebody who was challenging who brought the case when there was an election pending?
Yes, Your Honor, but it wasn't a candidate. It was a general citizen, and that was the basis on which they lost the suit. But the point is, Your Honor, this matter could come up again. We could have, again in 2012, the issue of Mr. Obama, who has already declared for re-election and filed his papers with the Federal Election Commission, running for president, and we still have the same issue. Is he eligible?
But you would be able, but the other half of it is incapable of review. It's likely to repeat incapable of review. That would not be incapable of review. Then somebody with standing could, in the course of that election, presumably raise the issue if they wanted to.
If we want to run this whole thing all through again, Your Honor, the facts...
Nothing's been done so far here. All you've done is you filed a complaint, and the district court has challenged standing. That's all we're here on today.
Yes, Your Honor.
So running it all through is not, doesn't seem to be a consideration. The question is, on standing, you can't argue that it is incapable of review. That's the only point I'm trying to address.
Okay. But I have other grounds for requesting remand by this court, Your Honor.
All right.
Your Honor, I entered this case on September 8th of 2009, 4 days after the government filed their motion to dismiss. In the short amount of time I had to prepare between then and when the motion to dismiss was had, we filed a motion for severance and to be allowed, and a motion for a proposed second amended complaint. It is our request that if the court is willing to grant remand, that we go back and proceed on those issues separate and apart from the other issues raised by Dr. Tates and her client. Now, the issue that appeared to be foremost, or one of the main issues that was foremost in Judge Carter's mind, was the issue of this being a political question.
But isn't standing logically prior?
Well, I can deal with that first if the court, if Your Honor.
If you don't have standing, you don't have standing. We don't get to political questions.
Well, this standing is involved in several issues which the judge discussed, Your Honor. One of them, whether the injury is redressable. And the Department of Justice argued that...
Well, the first question is, what's your injury? That's different than anybody else's. That's what I need to know.
Well, the injury, Your Honor, is that my clients, Mr. Robinson, then chairman of the American Independent Party, and Mr. Drake, who was the vice presidential candidate, were not given a level playing field so that they could run against a candidate who
Okay,
was
but
eligible.
they didn't file until the election wasn't completely over. The results were certified, and President Obama was sworn in. What did that have to do with the election?
Again, Your Honor, I'll have to defer to Dr. Tates on that. She's the one that filed the complaint. I was brought in for a variety of reasons much later in the process. I came in at the request of Dr. Drake and Mr. Robinson to try to salvage the situation, and we wound up with this appeal after argument before Judge Carter.
Well, you may, in fact, have the best standing, but I still don't quite see why you have standing.
Well,
I mean, you may be better than the rest of them, but I still don't see why you have standing.
As Judge Carter pointed out in his ruling, Your Honor, the ruling and the arguments made by the Department of Justice have grave ramifications for minor parties. I represent the vice presidential candidate and the then chairman of a minor party that ran a candidate. And Judge Carter talked at some length in his ruling, and in the transcripts he talked even further at length, and I argued at some length about how a ruling such as this, where for whatever reason a minor party cannot challenge simply because they are a minor party the ability of a major party to put forward a candidate that is not eligible, can in fact deprive the minor party of all relevancy and all status.
I thought Judge Carter was sympathetic to that, but still had the same concern Judge Berzon is raising, is that we're not in the posture of a campaign. That is not the posture of this case. If there is a campaign in which the minor parties feel that they are being unfairly disadvantaged for any number of reasons, have in the past, and there's no reason they couldn't in the future, raise the challenge you're trying to make. Now, you keep saying you were brought in late and that you have to deal the hand that you're dealt, we have to deal with the hand that exists, and you did not file a claim at the time when the kind of relief that you would be talking about might be plausible, but it doesn't do anything for your candidates now. We don't know whether they would run again in 2012, and if they do, and they have the concern that they express now, there's nothing to prevent them from filing a lawsuit at that time when the circumstances would be amenable to some kind of evidence as to injury, and we wouldn't have to speculate. But that's what I'm having trouble with.
I would direct your attention, Your Honor, to the Moody case, which we submitted from North Dakota, in which the State Supreme Court of North Dakota, after the election, after inauguration, after the governor of North Dakota had taken office and was acting as a governor, signing legislation, etc., the North Dakota State Supreme Court removed him from office because he did not qualify, did not satisfy, I should say, the residency requirements for the state of North Dakota. Now, that's about the most analogous situation I can come up with to this situation.
But as you've already said, the result of that would be that Vice President Biden would become president, and you're still where you were before.
No, Your Honor, the Constitution would have been upheld.
But your clients have no more, quote, level playing field than they did before, because this isn't about an election.
Your Honor, this is, to me, it's about the Constitution. And if...
Well, but what you're really saying is that anybody ought to be able to bring this case, and unfortunately, the law, that's not the law. And what I'm trying to see is how you're different than anybody else. I mean, do you begin from the premise that no, just somebody walking down the street does not have standing?
Well, I disagree with that, Your Honor. I think that the people of the United States have a fundamental right to enforce the Constitution.
That may be. Under the cases, the many, many years of precedents in the Supreme Court, can anybody bring the case?
Well, but not on this issue, Your Honor. We haven't had cases on this issue. You're talking about the cases of standing to object to tax levies and the like, and that I understand. But we have a situation right now which is unprecedented in law. We have a man who, whether it's true or not, arguably is not a citizen, or at least a natural-born citizen of the United States, and is thus not eligible to serve. And if we say, oh, the election's over, then basically we've said that the people of the United States, by a general vote of a plurality or a majority, can amend the Constitution without following the requirements of the two-thirds vote of Congress and the three-quarters of the states to do so.
Well, that's not quite true. I think the argument, and this gets into the political question, it's not that the people don't have a way to enforce the Constitution, and I don't recall what the North Dakota Constitution provided, but I understand the argument that's being made is that the Constitution addresses the issue. It has various stages at which the kind of challenge you're making could have been raised or could be raised at the Electoral College at that point, at the under the 25th or 26th Amendment. There are procedures. The question is, what is the role of the federal courts? Because that's why I asked you, just to be clear, why I asked you at the beginning what your ultimate relief is. Because what you want to do is take an action through the federal courts to remove a sitting president, and the Constitution has provisions that address how a sitting president can be removed from office. And that's the difficulty that, as federal judges of limited jurisdiction, we have to abide by.
Your Honor, first, if Mr. Obama is not a natural-born citizen, if he's not a citizen, then he never was elected president because he could not qualify to be president. Therefore,
that's an issue that would be identified or dealt with by the Congress or arguably perhaps the Attorney General.
Well, my point is, Your Honor, he could not be impeached. Unless you have a sitting president, you can't impeach him, number one. Number two, it was the argument of the Department of Justice, which Judge Carter seemed to bite on, that it was up to the Electoral College or the Congress to deal with this issue. The problem with that, as we argued in our brief, Your Honor, opening and reply, is that number one, 26 states in the District of Columbia have laws which mandate criminal or civil penalties for electors that do not vote in accordance with